Meet attorney Andrew F. Branca. He recently guested on the Tim Pool Show, and he was talking about self-defense laws and gun laws. At some point, the question centered on Dominick Black and whether he was going to get off on his gun charge now that Kyle Rittenhouse has had his charges dropped. That raises some interesting questions. And attorney Andrew Branca weighed in, and, well, the results were little less than desirable. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
They actually get another judge to say, oh yeah, that's a misreading of the law.
It's two different statutes.
Did you hear it? He said, another judge could say, yeah, that's just a misinterpretation of the law. Remember that. Now, Branca is going to weigh in. Listen what he says.
Black's case, they actually get another judge to say, oh yeah, that's a misreading of the law.
It's two different statutes. They're not charged under the same statute.
Okay.
That is true. Let's take a look at the statutes that they are charged under. This is Chapter 948.60 of the Wisconsin statutes, and we know it well. We go down here to Section 2, Paragraph A. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. That's Kyle. Subsection B, except as provided in Paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 years of age is guilty of a Class I felony. Okay, what does Paragraph C say? Well, Paragraph C basically says that if the gun, in addition, is used to really hurt somebody, you can be guilty of a Class H felony, a much stiffer sentence. Okay, so B and C refer to Dominick Black. So he's right. Kyle and Dominick Black are being charged under different statutes. Andrew Branca is going to go now a little bit further. And let's pay very careful attention to what he says.
But here's my question about that.
They're two different things. So the statute they charged Kyle with simply is inapplicable to his circumstances. I've done a lot of analysis on this.
I've done a lot of analysis on this. Yeah, later on he's going to say that he didn't do any analysis on this. Yeah, I mean, he actually does say that later. But that's okay. We'll let this one slide.
It's too lengthy to get into. But that statute is a completely different statute than Dominick Black is charged under. So the fact that Kyle's was dismissed has nothing to do with Black's, and Black's has nothing to do with Kyle's.
He's talking about the dismissal and the reasons for the dismissal. And he is saying that the reasons for the dismissal of Kyle's charge has nothing to do with Dominick's, and that Dominick's has nothing to do with Kyle's. Really? Let's go back and take a look at the statutes. Now he's not talking about being charged, he's talking about being dismissed. And he is saying that the dismissal of Kyle's charge is completely different than that of Dominick's, completely independent, has nothing to do with each other. Let's take a look. We go to subsection 3, paragraph C. The first one here, this first sentence, refers to Kyle. Then it says, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of these 3 subsections. I'm kind of being a little bit loose with my discussion there. What's important is that the next sentence refers to Dominick Black. They're in the same paragraph. And you will note that the exceptions are the same, with one small, very tiny minor edit, and that is the use of the word adult here for the 941.28, but it has no bearing on Dominick or Kyle's case. Therefore, you can't say that the dismissal of Kyle's charge has nothing to do with Dominick's and that Dominick's dismissal has nothing to do with Kyle's, because the dismissal is based on the same exception from the same statute. But that's okay. I mean, this is a little bit of verbiage, right? I mean, you're just a little disagreement on what he meant. So let's go back. All right. A lot of people complained, including me. I even made a video on it. Go back on my channel and watch. And Andrew Branca got really pissed off at people. Okay, let's listen to Andrew Branca explain his way out of this one.
Hey folks, attorney Andrew Branca here from Law and Self-Defense. It's come to my attention that some folks with a limited grasp of how the law works were confused by some of my commentary regarding the Dominick Black gun charge during my recent appearance on the Tim Pool IRL show.
Okay, this is called bluster. And that is if you're defending yourself, insult your audience to such a degree that they're going to be afraid to pipe up and disagree with you. It's a tactic. And it's used a lot by sovereign citizens. That's the reason why when they get pulled over, they're always threatening the police with $15,000 a day. I'm going to fine you. And I have won all these recent court cases that's given me a lot of money. You don't stand a chance. They roll it out. Basically, it's a frontal assault designed to cower down your opponent. Not going to work here, but it's a good try.
Always on the lookout for a teachable moment, I thought I'd take a few minutes to bring clarity to the confusion apparently plaguing some minds.
Not just complaining that maybe some people are confused out there. That's okay. But confusion plaguing people's minds, he's basically calling us stupid.
As usual, the problem is that some people are failing to fully engage their mental gears to the extent they think they are.
Oh, in other words, we're dumber than we think. We think we're smart, but we're actually kind of stupid. We're not able to engage our mental gears. Again, bluster, lots of insulting, all designed to make it to where a person doesn't feel confident in fighting back.
And as a result, they fail to understand even the actual question being answered, much less the correctness of the answer being provided.
Ah, he's made his first big mistake. He says that we didn't even understand the question. Nevertheless, the answer, there's only one small problem, Andrew Branca. You weren't asked a question.
Dominick's Black's case, they actually get another judge to say, oh yeah, that's a misreading of the law.
It's two different statutes.
Tim didn't ask him a question. Tim never said anything about which statutes the two boys were being charged under. What was his actual statement? He made a statement that the next judge that's asked could interpret the law, not particular statutes, but the law, which is the embodiment of all of the statutes, the common law. This judge could interpret the law differently. He didn't ask Andrew Branca a question at all. Let's go back.
So Dominick Black, you may recall, was the friend who purchased the AR-15 pattern rifle that Kyle Rittenhouse would use so successfully in self-defense in Kenosha, Wisconsin. Within days of that event, however, Rittenhouse was charged with a variety of crimes, including the misdemeanor of being someone under 18 years old in possession of a deadly weapon, that rifle purchased by Black. Not very long afterward, Black would find himself charged with his own criminal offense, that of having provided a minor with the deadly weapon, which was later involved in a death. Now, although both of these crimes are found in separate sections of a single statute, they are in every legal sense, nevertheless, distinct crimes with distinct legal elements. One can be guilty of one and not the other, or the other and not the one. Indeed, Rittenhouse was charged with the possession crime, but not the provision crime, and Black was charged with the provision crime, but not the possession crime, because possession and provision are two different crimes.
I notice he's on comfortable ground here. He's enjoying himself. He's going to go at length. He's going to go on and on and on. He's feeling good because he's talking about something that he knows a lot about. And you'll see in a minute why.
So I hope everybody's still with me. And if this explanation sounds painstaking, my apologies. It's because I found that certain folks need every single breadcrumb in the reasoning trail.
People stupid like me, well, you got to leave breadcrumbs laying around because we just can't follow an argument. I mean, we're just too stupid. Okay.
So the possession charge against Rittenhouse was dismissed shortly before his jury was given its final instructions and sent to deliberate. And rightfully so, as Kyle was never legally subject to the charged offense in any case for reasons I've covered in detail elsewhere. I'll link that in the text version of today's content. When the matter of the Dominick Black gun provision charge came up on Tim's show, the issue arose as to whether Black's gun provision charge should be dismissed because Kyle's gun possession charge was dismissed.
Wait a minute. What? Go back. Let's play it again. He's making a claim here. And it's wrong. Watch.
For reasons I've covered in detail elsewhere, I'll link that in the text version of today's content. When the matter of the Dominick Black gun provision charge came up on Tim's show,
which we just played,
the issue arose as to whether Black's gun provision charge should be dismissed because Kyle's gun possession charge was dismissed.
That was never the point. Again, go back to what Tim Pool said. He said that the next judge might interpret the law differently than Schroeder. He at no point ever asked or even stated that Dominick's charge should be dropped because Kyle's was dropped. Tim Pool's statement is born out of a concern for whether Dominick Black is going to be convicted for giving the gun to Kyle. And by the way, I keep saying Dominique, I guess. I keep trying to pronounce it Dominick, but everybody says it sounds like Dominique. Okay, sorry. So going back, that's what people want to know. They want to know what's the likelihood of Dominick being able to beat these charges. But what he has done is he's changed this thing into a legal argument, a pedantic classroom argument about whether one statute directly impacts another. Nobody cares about that. They want to know, given that Kyle has had his gun charges dropped, what's the likelihood of Dominick Black having his gun charges dropped? You have family members that are very worried about Dominick, and they want to know the answer to that question. Then you have Tim Pool, who wants Dominick convicted, and he wants that question answered too. So why didn't Andrew Branca answer that question? Actually, it was never even a question. It was just a statement made by Tim Pool. Well, we'll find out here in a moment why he didn't address that particular statement.
My answer was that I saw no reason why that would be the case. Now, let me restate that again, because precision of language is important in the law.
That's right. Precision of language is important in the law, and that's the reason why it's so important to go back and listen to what Tim Pool said. Tim Pool did not say anything about statutes. He said law. And by law, he's directly referencing not the statutes that Kyle and Dominick were charged under, but the exception. That's what everybody's talking about. That's what Schroeder ruled on. That's the big debate. And so Tim wants to know, is that exception also going to get Dominick off the hook? Dominick. Is that exception going to get Dominick off the hook? So precision of language, absolutely. When Tim Pool asked you about the law, you should have known he's not talking about the statutes under which these two boys were charged. Nobody cares about those.
My answer was that I saw no reason why Black's gun provision charge should be dismissed because Kyle's gun possession charge was dismissed. Pay attention to that because it makes all the difference. My answer to that question is the correct answer because the two statutes involved are distinct criminal violations, each with its own elements. Neither is itself an element or required component of the other.
And now he's going to go on and on and on because he's shifted the argument away from the discussion about the exceptions, which he knows little about, towards that of the charges, which he knows a lot about because they're very simple to understand. We already went over them. And so he's now on very safe ground, and he's very confident. That's why he's boasting so much here about how right he is. Well, he created what we call a straw man argument. And he made a very easy one. And now he's going to respond to that straw man argument and go on and on and on. Listen to this.
That is, there are factual scenarios in which one can be in criminal violation of having unlawfully provided a gun without the recipient being in unlawful possession of that gun. And there are factual scenarios in which one person could be in criminal violation of unlawful possession of the gun without the gun having been provided unlawfully. The crimes might occur simultaneously with each other, as the prosecution argued was the case with respect to Kyle and Black, and they were mistaken on the facts, but they need not necessarily occur simultaneously, as each is a distinct criminal offense and neither requires the other. Now, there are criminal offenses that cannot exist without the simultaneous presence of some other criminal offense, where one is a required element of the other or a predicate of the other. In that circumstance, the loss of the second required offense or predicate offense means that both legally dissolve. In such a case, one charge does disappear because the other has disappeared. So the charge of being an accessory to a crime, for example, requires the underlying predicate crime, such as someone being the lookout for a burglary actually being committed by another person. If someone has been charged as an accessory to burglary, but then it's determined that the other person's conduct was not burglary, then the accessory charge dissolves as a matter of law. The accessory charge cannot exist without the underlying predicate crime. In our example, there can be no accessory to burglary without the underlying predicate burglary. The accessory burglary charge disappears because the burglary charge has disappeared. They're connected. Similarly, the crime of felony murder requires an underlying predicate felony. If someone is charged with felony murder, but then the underlying crime is determined to be a mere misdemeanor or not a crime at all, the felony murder charge dissolves as a matter of law. The felony murder charge cannot exist without the underlying predicate felony. The felony murder charge disappears because the felony disappeared. They are interdependent. They are linked. Now, in theory, the Wisconsin legislator could have created such a dependency between the Black gun charge and the Kyle gun charge, such that one could not exist in the absence of the other. And in that case, the dismissal of one would necessarily result because of the dismissal of the other. That, however, is not Wisconsin law. There exists no such predicate relationship between the unlawful gun possession charge against Kyle and the unlawful gun provision charge against Black. They're unrelated criminal offenses, with neither being a required element or predicate of the other. They each stand alone, each independent of the other. Because they each stand alone, neither automatically gets dismissed or dissolved as a matter of law, simply because the other one no longer exists. Whether Black is guilty of unlawful gun provision is not dependent on whether Rittenhouse is guilty of unlawful gun possession, and vice versa. Two distinct criminal offenses, neither requiring the presence of the other. Or, as I said on Tim's show, there's no legal reason why Black's unlawful gun provision charge would be dismissed simply because Kyle's unlawful gun possession charge was dismissed. And that's 100% correct. It was correct on Tim's show, and it's still correct today.
Yeah. Okay, we get it. We get it. All he is saying is, guess what? Kyle's offense is here. Dominick's offense is here, and they're not in the same statute.
Now, there's a different question that I was not answering, and if I had been answering the different question, my answer would have been different.
You were never asked a question. And I defy you to go back into that original Tim Pool interview. You tell me what question you were asked. You weren't asked a question. And you certainly weren't asked the question about whether Dominick's charges were going to be dropped because Kyle's charges were dropped. You were not asked that question, but you created this. This is called, again, the classic straw man argument.
And I'm afraid there are a lot of people who heard me answer the question of whether Black's charge gets dismissed because Kyle's charge got dismissed, and
I defy anybody to find that question in the interview.
imagined that I was answering this entirely different question. And what's the different question? This. Does the unlawful gun provision against Black share the same exclusion provision as does the unlawful gun possession charge against Rittenhouse?
That's what Tim Pool was trying to get at. When Tim Pool brought up the law and how somebody might interpret it differently, he was talking about the interpretation of the exceptions, not the original charges. Come on. Why didn't he just go on and on and on about that question like he did the other one? Well, he'll tell you here in a minute.
In other words, is there a common exclusion mechanism that can apply independently to each of those charges, regardless of the status of the other, or even if the other was never charged at all? As it happens, the answer to that question is yes.
Well, that's what we were wanting to know. Oh, jeez, dude. Step out of the classroom for a moment. Get to understand the real world. When it comes to people like Dominick Black, who's being persecuted, people want to know if he's going to go to jail. They're not interested in your damn legalese bullshit. Tim Pool brought up the issue because he wants to know, is Dominick going to go to prison? Why didn't you answer him? Well, to be honest, he didn't even ask you a question, although you're claiming he did.
The unlawful gun provision charge against Black happens to enjoy the same exclusion provision as does the unlawful gun possession charge against Kyle,
which we all knew, but he didn't.
Accordingly, Black's gun charge should be dismissed for the same reason Kyle's gun charge should be dismissed.
Well, there you go. In other words, the dismissal of Kyle's does have something to do with Dominick's. Come on.
But that's not the same thing as saying that Black's charge should be dismissed because Kyle's was dismissed.
Yeah, but you don't care about that.
There is no because the two statutes are not dependent on each other. Each ought to be dismissed on its own legal merits, and that would be true even if the second charge had never been brought. Again, there is absolutely no dependency between the two at all. The question I answered on Tim's show was whether Black's charge gets dismissed because Kyle's charge got dismissed.
You didn't answer that question. You were never asked that question.
And the answer to that question was correctly answered no, is correctly answered no, and remains correctly answered no, unless the relevant statutes are changed sometime in the future. The question I was not answering on Tim's show was whether the exclusion language that applied to Kyle's gun charge also applied to Black's gun charge. It should go without saying that I can't very well provide a wrong answer to a question I wasn't answering in the first place. Now, had I been asked on Tim's show whether the exclusion language applied to both charges, I would have answered, I don't know.
Thank you. Thank you. That's the first non-bullshit thing you've said. You didn't know. That's why you didn't answer to Tim's prompt about whether Dominick was going to go to prison or not. The response to Tim's point rests in the exceptions, not the original charges. But you didn't read them before you went on his show. That's why you couldn't answer to it. So you changed the argument. Now, people like me, we could have answered it. I could have. I have videos on it. But you weren't prepared. Now, why? Wait till you hear his excuse.
My interest is not gun law. It's use of force law.
Your interest is self-defense law. It's not gun law. You spent 15 minutes telling us all about these various things about the gun laws that Kyle and Dominick were charged under and how one doesn't necessarily affect the other. Now you're telling us, well, I'm not interested in gun laws. Okay.
I have no great interest in the criminal charge against Black and hadn't bothered looking at it closely prior to my appearance on the show, but I wasn't answering that question.
You weren't answering any question. Come on.
The question I was answering was whether Black's charge gets dismissed because Kyle's charge got dismissed.
Yeah, enough of that. Now, we all pointed out that he made a mistake. He blew it. He didn't come prepared. But that's okay. I mean, look, I'm not going to blame him for that so much. He had no way of knowing whether that question was coming at him. And if he had just built a video and saying, hey, the reason why I got wrong there was because I hadn't read that exceptions clause and I just wasn't prepared for it, we would all have said, oh, okay, fine. You know, what the hell, man? You're on an interview, you're going to get asked a lot of questions, you're not going to be prepared for all of them. But instead, what did he do? He created a straw man argument, changing the question over to something he was comfortable with. And so he then just goes on and on and on about it. Now, I raised this thing up in the comment section. Let's watch. I wrote, sorry, but you created a straw man argument to wiggle out of the mistake you made on Tim's show. Tonight, I'm pushing out a video that explains why. And I posted that yesterday, but I got tired. I didn't get the video out. He responds back, I wish you the best of luck growing your channel. In other words, Ha, 500 subscribers? You mean nothing to me. All right? Now you might think, oh, come on now, you're being harsh. He could have been well-meaning in that, right? No, let's read the next. Well, I did respond. Oh, a little jab about my number of subscribers. Now look at my next comment. Wait, did you really say? And if you were confused about what I said, why didn't you just ask? I could have explained it to you in small words and saved you the embarrassment. I could have explained it to you in small words and saved you the embarrassment. Now, why isn't his comment there? Because he deleted it. But I was able to copy paste it off of my notifications. So, Andrew Branca thinks he's smarter than me. Well, he knows the law more than me. And by the way, I don't want to get on him too much, although I think he's an arrogant prick for the way he talked to me and the way he talked to anybody who dared question his understanding of Wisconsin's gun laws. But I mean, he knows his stuff. His self-defense book is probably very good, and I certainly would advise people who want to be able to defend themselves to go out and buy it. They will learn a lot. He has a really good channel. He's got more subscribers than me, of course, than everybody does. So, Andrew Branca, I'm just going to tell you this. You know a great deal about self-defense laws. Hell, you wrote the book on it. You're probably the nation's top expert at it, and your book is probably fantastic, okay? But you're not smarter than me. Like my video, subscribe to my channel.